So one of the big news stories of the summer was the Supreme Court decision that came down in June regarding the U.S. versus Windsor case, which struck down a major part of the Defense of Marriage Act, or DOMA, and this has a huge impact on tax law.
And definitely on immigration law as well, because it is federal legislation, it's federal law. So it had a ripple effect not only through the tax world, but also through immigration as well.
And certainly in global mobility as well.
Sure, sure. Well, what's interesting about the tax implications is that while it settled some things, it also raised all sorts of questions that we don't know how are going to be answered. The part of DOMA that the Supreme Court struck down was the part that said that the federal government is not allowed to recognize same-sex marriage. So now the federal government does recognize legal same-sex marriages if they're performed in a place that allows it. The part that the Supreme Court did not strike down is the part that says that states are allowed not to recognize same-sex marriages performed elsewhere. So if you're a same-sex couple that moves from a state where it's legal to a state where it's not legal, or if you're a couple that lives in a state where it's not legal and you go get married somewhere else, there was a lot of confusion about what that was going to mean. The IRS released Revenue Ruling 2013-17, and what that says is that if a same-sex couple is legally married somewhere, they'll be considered to be legally married for all federal tax purposes. Every federal agency has to decide for themselves how they're going to interpret the Supreme Court ruling, but that's the IRS's position, and that means that essentially, if a couple can get themselves to a state where they're allowed to get married, they'll be considered legally married. So that's a lot more clarity for same-sex couples themselves. There are still a few points of unclarity or confusion. For example, underpayment of taxes. They may not have paid in enough withholding and estimated payments because they thought they were going to be filing single for 2013, so they'll need to get more paid in. And in addition, they'll be required to file as married for 2013, but they're allowed to go back and amend their returns for prior years, so they'll want to look at whether that's beneficial or not. Employers have much more confusion that they have to deal with. First of all, a lot of employers provide partner benefits for same-sex partners, and that's a taxable benefit. So now employers are going to need to determine which couples are actually married and which are just registered domestic partners or in civil unions, because for the married couples, it will no longer be a taxable inclusion, but for the others, it will be a taxable inclusion. And related to that, the IRS has also provided some guidance with respect to how to get benefit payment refunds because they may be paid in too much for their payroll taxes. The benefit plans themselves, however, may have to be amended, and there's no guidance on that at all, and that could be a very large undertaking if there's a lot of employer benefits plans. So the IRS is saying that they'll have an answer for us by the end of the year. We're hoping that's the case. Right now, couples have clarity, but employers not so much.
It's very interesting because on the immigration side, there is not a lot of uncertainty. USCIS was mandated on July 1st by Department of Homeland Security to move forward with recognizing all same-sex marriage filings and to give the same benefit as they would to a heterosexual couple filing as they've had in the past. And they've been very clear that they will be moving forward with all the benefits that relate to that. The good thing is that in the past, historically, the U.S. has not been advanced as many of the other westernized countries, such as Canada and the UK, in recognizing same-sex marriages. And so they were very limited into a large amount of the labor pool that was coming into the U.S. This new legislation opens up a wide variety of movement, which crosses the global mobility lines and comes into the immigration world, because now individuals who chose not to come to the United States for purposes of work were now able to come and to immigrate for family and work benefits. Sure. Because now they're getting the same benefit. Not only is this given to permanent residents, which is the most popular topic that's been discussed, but all other derivative benefits under the work permit categories as well. So that's a real benefit for individuals who have thought about coming to the United States as family-based sponsors and or work-related sponsors for labor and employment purposes to come, because now they will be given an entire benefit. They can go to school, they can work while their spouses are here. And there's been no hesitation on the part of the USCIS. And retroactively, they will be going back to a lot of the cases that were filed post February 11th and were denied by that point. And so they're opening up those cases, re-adjudicating them. And they're doing that immediately. Wow. And so they've been very clear that they will not hesitate in viewing them, because it is federal law, that they will be viewing them equally across the board, and all benefits will be given just as they are given to previously heterosexual couples.
So what if you have the situation of, say, a same-sex married couple from Spain, and they're going to be coming to the U.S. to live in, say, Florida, that doesn't recognize same-sex marriage?
That's a very good point. They've been very clear in that questioning as well, that as long as your marriage is legally recognized in a jurisdiction, whether that be a state in the United States or a foreign country, they will also recognize that marriage and provide you with the benefit. So for example, there was a couple that received one of the very first few permanent resident same-sex partner benefits. They live in Florida, a state that does not recognize same-sex marriage, but were married in New York. And so they were provided the benefit because it is a federal benefit. And also, if you come from Canada, let's say, where you have a same-sex marriage that's lawfully recognized, and you move to the United States, it will be recognized as well, even if you're residing in a state that does not recognize same-sex marriage.
So employers have much more clarity now for immigration purposes, but not so much for employee benefits. So I really don't envy the program administrators who have to deal with this.
Yeah, I mean, the degree of change is really amazing, as you can see within global mobility, and in particular with international assignment policies. I think more and more we're going to see program managers that are probably going to be approached by their gay and lesbian assignees for certain changes to their assignment packages. But probably most importantly at the beginning stage, individuals now approaching saying, I want to bring my spouse on assignment with me. But particular to international assignment policies, we probably could see challenges to, for example, housing allowances, cost of living allowances, transportation costs to and from the host country, and even home leave, for example. We'll see the impact of policies and also the adjustments that will be needed at the individual assignee level. And we'll also look at the overall tax impact, most likely. So we'll see perhaps changes that will need to be made to original accruals for assignment costs that will now be impacted by the change to the assignment package itself.
Are you seeing companies change their policies already, or are they waiting for more guidance from IRS?
I think they're waiting for more guidance now to come out still, but certainly these issues are at the forefront, and I think we'll start seeing specific changes to international assignment policies, yes.
Well, Glenn, as you know, with global mobility and immigration work hand in hand together many of the times. So we have seen already some changes come through where we've had to go back to global mobility and have to form a policy very quickly. We're working with a lot of them now to try and work hand in hand on how this benefit will be able to be derived, working with current global mobility programs.
So lots of change and more to come. It looks like we're going to be having more of these conversations.
Look forward to it.
Great.